The webinar will begin in 1 minute. Welcome, everyone. We are pleased that you've joined us for today's webinar entitled Asset Protection Planning, an Imperfect Guide. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Limeberg, and Linus regularly speaks at industry events. Before I turn it over to Linus, we are going to vote on November's webinar. The options for the November webinar are private letter ruling, confirm spousal stretch options, dynasty trust planning, or estate tax return mistake costs $1.5 million. I'm going to launch the poll and give everyone a minute to vote. All right, you got about 15 more seconds to get those final votes in. All right, it looks like the topic for the November webinar will be Dynasty Trust Planning. So join us on November 5th for that. And as a reminder, join us on October 1st for life insurance and tax uncertainty. And with that, I will turn the webinar over to Linus.
Welcome, everyone. I'm happy that you have joined us for today's webinar titled Asset Protection Planning, an Imperfect Guide. I'm Linus Sugis, and I'm glad to be presenting the information for today's webinar. As a reminder, we have these webinars on the first Wednesday of every month at 11 o'clock Central Time. The next webinar will be on Wednesday, October 1st at 11 o'clock Central. and the topic will be life insurance and tax uncertainty. These webinars are free of charge and open to everyone who is in the life insurance or financial planning business. If you know someone that you feel could benefit from the content that we provide, please feel welcome to invite them to attend the webinar. Thank you for that. Let's go ahead and get started on asset protection planning and imperfect guide. We're going to cover 4 areas, and we're going to cover them pretty quickly in 20 minutes or so. We're going to start with a general explanation of the rules with regard to asset protection planning. We're going to show you a quick court case that I think underscores the difficulty in giving straight answers to questions. A lot of our callers complain that we don't give them straight answers to asset protection planning questions, and there are a lot of reasons for that, and the court case is one of them. We'll talk over some state-specific rules for 6 specific locations, and we'll take a quick look at a chart for all 50 states plus one more for the District of Columbia, and we'll tell you how you can get that. And then we'll give you some practical advice at the end for what to tell a client when your client asks you asset protection questions. So let's go ahead and get started with some general background. So it's not unusual for clients to ask asset protection questions. And when we talk about asset protection and asset protection planning, we're usually referring to the legal ability to protect assets, whether they're personal or business, from the claims of creditors. And one of the things that makes asset protection planning difficult is that each state has its own rules with regard to asset protection, and the laws may apply differently in different circumstances with regard to different kinds of assets and different kinds of creditors. So all of those are potential moving parts with asset protection planning. Having said that, how difficult it is to give straight answers, we do want to help our clients some, and so that's why we're talking about this today. We hope to give you at least some familiarity with these concepts so that you can begin to educate your client about asset protection. Another one of the reasons why asset protection planning is difficult is that clients, believe it or not, don't always tell us the whole story when they ask us questions about specific asset protection techniques. So there are different kinds of liabilities that clients may be trying to manage when they ask an asset protection question. One type of liability that they might be trying to manage is against unknown future creditors. For example, a doctor may not have been sued until the current time, but is worried about potentially being sued in the future and not having adequate or proper medical malpractice insurance to cover the liability, and so the doctor may be worried about unknown future creditors. And in general, asset protection strategies are most effective with regard to unknown future creditors. If a client has a creditor that the client already knows about, there are pretty stout rules in effect everywhere which say that if you try to make a transfer in order to cheat a creditor that you know about, a court has the power to undo a transfer of that type and allow the creditor to have access to that asset where they normally wouldn't be able to have access to that asset. This kind of transfer by the client is called a fraudulent transfer, and it's the kind of transfer that can be undone by a court and allow a creditor to have access. And then there are creditors that have special status. For example, if you have a client who is divorced or getting divorced and there is a liability to the ex-spouse with regard to alimony, perhaps with regard to child support, a client should not expect the general asset protection rules to protect the client in those circumstances. If the creditor is the IRS or another federal agency, the client shouldn't expect normal asset protection rules to protect the client if the IRS is their creditor. There are very stout federal rules that would allow federal agencies, including the IRS, to break through state asset protection situations. In fact, the federal government has criminalized attempts where taxpayers try to avoid paying the IRS by making fraudulent transfers. Now, like I mentioned earlier, each state's got its own rules about asset protection, and the effectiveness of those rules depends on all of the facts around the liability. Asset protection rules in the abstract are also different in some circumstances from bankruptcy rules. When a client files bankruptcy, certain kinds of assets may be exempt from being reached by creditors, but only in a bankruptcy situation. And so there's a difference between generic asset protection and protection in bankruptcy. Sometimes those rules are the same in a particular state, but to make matters even more complicated, sometimes a client doesn't get the state protections, the client gets the federal protections, which generally do not protect things like life insurance and annuities to any great extent in bankruptcy. And so encouraging clients who are considering bankruptcy to talk things over with a bankruptcy attorney can help sort through some of those kinds of issues. And people often get asset protection rules confused with Medicaid planning rules. For Medicaid planning, somebody's got to be poor in order to qualify for Medicaid benefits. Some assets that might be exempt from the claims of creditors might still be countable assets for Medicaid purposes. And so it's important not to confuse the two. There are certain specific assets that may be exempt from Medicaid, but that's not the same as asset protection in the statute. And it's always the best advice for clients to have a conversation with a local experienced elder care attorney when trying to sort out Medicaid qualification issues. So I want to talk quickly about a court case, Shah versus Balak out of the Western United States, which was decided in 2017. We've got a situation where Syed Shah sued Abdul Balak for breach of contract and got a judgment for more than $400,000. Shah tried to collect from Balak's 401k account, which had a balance of $50,000. And Shah said that while a 401k account is generally exempt from the claims of creditors, Balak had fraudulently transferred several $1,000s into the account, and therefore Shah should be allowed to get at the money in the 401k account. Now, Wells Fargo, which held the funds, said it wasn't going to release them based on the federal protections of ERISA, and the Arizona lower court agreed with Wells Fargo. Shah appealed to the Arizona Appeals Court, and the Appeals Court recognized that Arizona's got laws about fraudulent transfers that we talked earlier, recognized that Balak owed Shah money, and after owing Shah money, had transferred some money into the 401k account. And the Arizona statute says if a transfer is made with intent to hinder, delay, or defraud, then the asset is potentially available to the creditor. Balak, on the other hand, said, look, federal ERISA law is an absolute protection for the funds that are in the 401k account. And so what did the appeals court say? The appeals court said that there was no dispute that the 401k plan is a qualified plan, that under ERISA rules, there is no ability to alienate the money in a 401k plan. The court said, look, when there's a conflict between federal law and state law, the federal rule controls. Um, and even though Shaw correctly argued that Bollock should not have been allowed to transfer the money based on fraudulent transfer rules in Arizona, the court ultimately decided that ERISA was a complete protection of the fraudulent transfer against the fraudulent transfer rule and found in favor of Bollock. Now, there are a lot of moving parts in that decision. The reason I'm going through it is that it is really, really hard to predict how words in a statute or interpretation of words in a statute might ultimately be decided. And that's why, because of that ambiguity, because of the number of moving parts that we've touched on earlier, it's why it is so very hard to try to give straight answers to clients on their asset protection questions. In addition to that, sometimes the statutes in various states are not as clear as we would like them to be. For example, in Delaware, the Delaware statute is about as clear as you can get. It is clear that retirement plans, life insurance contracts, and annuity contracts all are exempt from the claims of creditors in the state of Delaware. On the other hand, in Maryland, if you read through the statute language that we've reproduced here in the slide, what it says is that it makes a difference who the beneficiary of the particular contract is as to whether or not asset protection will be effective. It's got to be for the benefit of spouse, child, or dependent relative in order to be protected from the claims of creditors. So that's an interesting difference between Maryland and Delaware. In Washington, D.C., it's even more complicated. Retirement plans are protected from the claims of creditors, and life insurance is also protected from the claims of creditors. The life insurance protection is fairly broad. The IRA and retirement account protections are fairly broad, but there is no protection, explicit protection for non-qualified annuities. So non-qualified annuities are not protected by statute in Washington, D.C. In West Virginia, the protections feel like they are fairly broad. With regard to annuities, though, it feels like the protection only is effective in the event of bankruptcy. Hard to say for sure, but that seems to be what the rule says in West Virginia. In Virginia, just like in Delaware, the claims, the statutes seem to be fairly clear. The protections are broad for both life insurance and annuities, whether the annuities are qualified or non-qualified. And then to finish that up, in North Carolina's rule seems to limit the protections of life insurance only when family members or dependents are beneficiaries of the contract. Annuities, if they are qualified, seem to be protected. Non-qualified annuities seem not to be protected. So there you go. It's a mishmash of rules depending on which state you're in. And even in a state where you've got rules, sometimes those rules aren't as clear as we would like them to be. We don't always have a firm grasp of all the facts that are relevant to a client. And in some cases, we have a conflict between federal rules and state rules that might intervene. And so that's why it's so hard for those of us who work in this business to give straight answers to asset protection questions. Here's a quick look at a chart we produced with regard to asset protection rules by state. These are summarized in a table format, but for a complete answer and to double check to make sure that the information here has not been superseded, my strong recommendation is that you either call us or you go to the statute to check to see if anything has changed. If you email us after the webinar and request the materials, we'll send you a copy of the newsletter that we've written on asset protection planning, which also contains a copy of this chart so you can look it over at your leisure for the states that are important to you. So what practical advice would we give to you in answering asset protection planning questions for your client? As we've hopefully demonstrated in a short period of time, because asset protection and bankruptcy rules are complex, giving reliable answers to a particular client is very difficult. And so when you call in with an asset protection question, don't be offended if Jennifer or I give you a very cautious answer, because we don't know what it is that we don't know, particularly about the client's situation. And so having perfect information about that would be necessary to give a reliable answer. And even then, sometimes the answer isn't all that clear because of some ambiguity in state laws. State variations add to the difficulty. The client situation makes a difference in the answer. But from our perspective, we like the fact that hopefully you are as aware as you can be about general asset protection rules as they might affect your clients. You can at least start to answer the questions that your clients have and ultimately refer your clients to a competent attorney, local, for specific protection advice that they can rely on in the situations that they're worried about. So what conclusions do we draw today? First of all, be prepared to give a client who asks asset protection questions a decent starting point, but take some care, warn them about the limited usefulness of the general answer, and stress how important it is for the client to discuss their situation with a local attorney. I'd like to thank you for joining us today. As a reminder, if you'd like to receive supporting materials that I mentioned during the webinar, feel welcome to email us at asktheexpert@advancedunderwriting.com. That's asktheexpert@advancedunderwriting.com. You may also email questions related to today's content. Feel welcome to join us for the next webinar on the first Wednesday of next month, October 1st, at the same time. Next month's webinar will be titled Life Insurance and Tax Uncertainty. You can also find an archive of past webinars on our YouTube channel, Advanced Underwriting Consultants. Please subscribe to our channel. It helps us to keep making free webinar content. Today's presentation will be posted on our YouTube channel by the end of this week. And finally, for more information about the services that Advanced Underwriting Consultants offer, including phone consultation and newsletter licensing, feel welcome to contact us at 615-224-1291. That's 615-224-1291. Thanks again, and best wishes for continued success.